The Judiciary Committee will now proceed with the confirmation hearing for Judge Alito for the Supreme Court of the United States. Welcome back, Judge Alito. We have 3 members who have not had their first round of questioning of 30 minutes, and we will proceed there. And then we will have a second round of questioning for 20 minutes each. I expect we'll need to work a long day today. It's my hope that we might finish the questioning of Judge Alito. That may be overly optimistic, but we'll see how things go. Senator Durbin, you're recognized for 30 minutes.
Thank you very much, Mr. Chairman.
Before we start the clock on Senator Durbin, if I might say on the questions, one, I admire the stamina of both of the nominee and his family. But a number of us have been troubled by what we see as inconsistencies in some of the answers, and we're going to want to go into those in some depth on the issue of one person, one vote, vanguard, recusal, unitary government, unitary theory of government caps, and so on. I want to clear up in my own mind and the mind of many over here, what we see as inconsistencies. I know many have announced up here exactly how they're going to vote before they even ask questions. I'm one of the ones that like to make up my mind after asking the question, so there will be a number more.
Well, thank you, Senator Leahy. I appreciate the comment. There are many issues. Judge Alito has responded for about 7.5 hours so far, and we're going to have another hour and a half on opening statements, and then with each senator having 20 minutes on a second round, there are 6 more hours. So we'll see if he has covered the waterfront, and this will be a full and fair hearing. We will give every opportunity to ask the questions.
Mr. Chairman, with you as chairman, I know it will be a full and fair hearing, and that's one thing that every single Democrat on this side is aware of.
Well, I think that's very important for the nominee, for the committee, and for the country, and we will do that. And the adjunct to full fair is dignified, and I think so far we're on track. Okay, Senator Durbin, keep us on track. Senator Durbin's recognized we'll restart the clock at 30 minutes.
Thank you very much, Mr. Chairman. Judge Alito, thank you for coming for the second day and not quite the end of the first round. I thank your family for their patience listening to all of our questions, and I hope that at the end of the day we'll feel that we've really added something to the process of choosing a person to serve in a lifetime appointment to the highest court in our land. I listened to you carefully yesterday address an issue which is very important to me, the Griswold case, because I think that it's a starting point for me when it comes to appointments to the Supreme Court. If I had any doubt in my mind that a Supreme Court nominee recognized the basic right of privacy of American citizens as articulated in Griswold, I couldn't support the nominee. And I listened as you explained that you supported that right of privacy and that you found the Griswold decision grounded in the Fifth Amendment as well as the 11th Amendment. I'd ask you at this point, you obviously support Brown versus Board of Education, do you, and the finding of the court? In
Certainly, Senator.
And do you believe that the Constitution protects the right of children in America to be educated in schools that are not segregated?
Absolutely, Senator. That was one of the greatest, if not the single greatest thing that the Supreme Court of the United States has ever done.
And as you read that Supreme Court decision, that historic decision, they find the basis for that decision, the Equal Protection Clause of our Constitution.
Yes, they did. That was, I think, of course, we fought a civil war to get the 14th Amendment and to adopt the constitutional principle of equality for people of all races.
The reason I ask you about those 2 cases is that neither of those cases referred to explicit language in the Constitution. Those cases were based on concepts of equality and liberty within our Constitution. And the Griswold case took that concept of liberty and said it means privacy, though the word is not in our Constitution. And the Brown versus Board of Education case took the concept of equality, equal protection, and said that means public education will not be segregated. I raised that because I listened carefully as Senator Schumer asked you yesterday about Roe versus Wade. And I couldn't understand your conclusion. You conceded the fact that we have free speech because it's explicit in our Constitution, protected constitutional right. And yet, when Senator Schumer asked you repeatedly, do you find that Roe versus Wade established and recognized a constitutional protection for a woman to make this most private decision? You wouldn't answer. You wouldn't give a direct answer. On two Supreme Court cases, Griswold and Brown now, you have said, just right as we started this hearing, that you believe there is a constitutional basis for this protection and for this right. And yet, when it came to Roe versus Wade, you would not. Most of us are troubled by this 1985 memo. You said yesterday you would have an open mind when it came to this issue. I'm sorry to report that your memo seeking a job in the Reagan administration does not evidence an open mind. It evidences a mind that sadly is closed in some areas. Yesterday, when you were asked about one man, one vote, you clarified it, said those were my views then, they're not my views now. When Senator Cole asked you about the power and authority of elected branches as opposed to others, no, you said I want to clarify that's not my view now. And yet, when we have tried to press you on this critical statement that you made in that application, a statement which was made by you that said the Constitution does not protect a right to an abortion, you've been unwilling to distance yourself and to say that you disagree with that. I think this is critically important because as far as I am concerned, Judge Alito, we have to rely on the Supreme Court to protect our rights and freedoms, especially our right to privacy. And for you to say that you're for Griswold, you accept the constitutional basis for Griswold, but you can't bring yourself to say there's a constitutional basis for the right of a woman's privacy when she is deciding, making a tragic, painful decision about continuing a pregnancy that may risk her health or her life. I'm troubled by that. Why can you say unequivocally that you find constitutional support for Griswold, unequivocally you find constitutional support for Brown, but cannot bring yourself to say that you find constitutional support for a woman's right to choose?
Brown versus Board of Education, as you pointed out, is based on the Equal Protection Clause of the 14th Amendment. And the 14th Amendment, of course, was adopted and ratified after the Civil War. It talks about equality. It talks about equal protection of the law. And the principle that was finally recognized in Brown versus Board of Education after nearly a century of misapplication of the 14th Amendment is that denying people the opportunity, people of a particular race, the opportunity to attend schools or, for that matter, to make use of other public facilities that are open to people of a different race denies them equality. They're not treated the same way. An African American is not treated the same way as a black person when they're treated that way, so they're denied equality. And that is based squarely on the language of the Equal Protection Clause and the principle, the principle that was the magnificent principle that emerged from this great struggle that is embodied in the Equal Protection Clause. Griswold concerned the marital right to privacy, and when the decision was handed down, it was written by Justice Douglas, and he based that on his theory of emanations and penumbras from various constitutional provisions, the Ninth Amendment and the Fourth Amendment, and a variety of others. But it has been understood in later cases as based on the Due Process Clause of the 14th Amendment, which says that no person shall be denied due process, shall be denied liberty without due process of law. And that's my understanding of it. And the issue that was involved in Griswold the possession of contraceptives by married people is not an issue that is likely to come before the courts again. It's not likely to come before the Third Circuit. It's not likely to come before the Supreme Court. So I feel an ability to comment, a greater ability to comment on that than I do on an issue that is involved in litigation. And what I have said about Roe is that if the issue were to come before me, if I'm confirmed, and I'm on the Supreme Court, and the issue comes up, the first step in the analysis for me would be the issue of stare decisis, and that would be very important. The things that I said in the 1985 memo were a true expression of my views at the time from my vantage point as an attorney in the Solicitor General's office, but that was 20 years ago, and a great deal has happened in the case law since then. Thornburg was decided, and then Webster, and then Casey, and a number of other decisions. So the stare decisis analysis would have to take account of that entire line of case law. And then if I got beyond that, I would approach the question, and of course in Casey, that was the beginning and the ending point of the analysis in the joint opinion. If I were to get beyond that, I would approach that question the way I approach every legal issue that I approach as a judge, and that is to approach it with an open mind and to go through the whole judicial process, which is designed, and I believe strongly in it, to achieve good results, to achieve good decision-making.
Well, and this is what troubles me, that you do not see Roe as a natural extension of Griswold, that you do not see the privacy rights of Griswold extended by the decision in Roe, that you decided to create categories of cases that have been decided by the court, that you will concede have constitutional protection, but you have left in question the future of Roe versus Wade. Yesterday, Senator Specter asked you, as he asked John Roberts before you, a series of questions about whether or not you accept the concept that this is somehow a precedent that we can rely on, that is embedded in our experience, that if it were changed, it would call into question the legitimacy of the court. And time again, he brought you to the edge, hoping that you would agree, and rarely, if ever, did you acknowledge that you would agree. You made in the most general statement that you believed reliance was part of stare decisis. But let me just ask you this. John Roberts said that Roe versus Wade is the settled law of the land. Do you believe it is the settled law of the land?
Roe versus Wade is an important precedent of the Supreme Court. It was decided in 1973, so it's been on the books for a long time. It has been challenged on a number of occasions, and I discussed those yesterday, and the Supreme Court has reaffirmed the decision, sometimes on the merits, sometimes in Casey, based on stare decisis. And I think that when a decision is challenged and it is reaffirmed, that strengthens its value as stare decisis for at least two reasons. First of all, the more often a decision is reaffirmed, the more people tend to rely on it. And secondly, I think stare decisis reflects the view that there is wisdom embedded in decisions that have been made by prior justices who take the same oath and are scholars and are conscientious, and when they examine a question and they reach a conclusion, I think that's entitled to considerable respect. And of course, the more times that happens, the more respect the decision is entitled to, and that's my view of that. So it's a very important precedent. That
is it the settled law of the land?
It is a precedent. If settled means that it can't be re-examined, then that's one thing. If settled means that it is a precedent that is entitled to respect as stare decisis, and all of the factors that I've mentioned come into play, including the reaffirmation and all of that, then it is a precedent that is protected, entitled to respect under the doctrine of stare decisis in that way.
How do you see it?
I've explained, Senator, as best I can how I see it. It is a precedent that has now been on the books for several decades. It has been challenged. It has been reaffirmed. But it is an issue that is involved in litigation now at all levels. There is an abortion case before the Supreme Court this term. There are abortion cases in the lower courts. I've sat on 3 of them on the Court of Appeals for the Third Circuit. I'm sure there are others in other courts of appeals or working their way toward the courts of appeals right now. So it's an issue that is involved in a considerable amount of litigation that is going on.
I would say, Judge Alito, that it is a painful issue for most of us. It is a difficult issue for most of us. The act of abortion itself is many times a hard decision, a sad decision, a tragic decision. I believe that for 30 years we have tried to strike a balance in this country to say it is a legal procedure, but it should be discouraged. It should be legal but rare, and try to find ways to reduce the incidence of abortion. But as I listen to the way that you've answered this question this morning and yesterday, and the fact that you have refused to refute that statement in the 1985 job application, I'm concerned. I'm concerned that many people will leave this hearing with a question as to whether or not you could be the deciding vote that would eliminate the legality of abortion, that would make it illegal in this country, would criminalize the conduct of women who are seeking to terminate pregnancies for fear of their lives and the doctors who help them. That is very troubling, particularly because you have stated that you are committed to this right of privacy. If I could move to another issue that came up yesterday, I didn't understand your answer to one question, and I want to clarify it. This so-called Concerned Alumni of Princeton, you noted in your application for a job with the Department of Justice you belong to 2 organizations, the Federalist Society and the Concerned Alumni of Princeton. I won't get into the Federalist Society because every time I say those words, they go into a rage that I'm somehow guilty of McCarthy-like tactics, asking who are these people in the Federalist Society. I won't touch it. Let me just go to the Concerned Alumni of Princeton. I didn't understand your answer. Your answer said something about ROTC being discontinued at Princeton University. I know you were involved in ROTC. I'm told that by the time you filled out this application, ROTC had been restored. I don't believe you were suggesting that bringing more women and minorities to Princeton would somehow jeopardize the future of ROTC. I don't know that that's the case. But there is a woman named Diane Weeks who was a colleague of yours in the New Jersey U.S. Attorney's Office. And she said that she was troubled by your membership in this group. She said you had a first-rate legal mind, but here's what she went on to say. When I saw Concerned Alumni of Princeton on that 1985 job application, I was flabbergasted, she said. I was totally stunned. I couldn't believe it. Cap made it clear to women like me we were not wanted on campus. And he is touting his membership in this group in 1985, 13 years after he graduated. He's not a young man at this point, she said, and I don't buy for a second that he was doing it just to get a job. Membership in CAP gives a good sense of what someone's personal beliefs are. I'm very troubled by this, and if I were in the Senate, I would want some answers. I don't think explaining discontinuing ROTC at Princeton is an answer. What is your answer? Why did you include this controversial organization as one of your qualifications for being part of the Reagan administration? As you said, with your background, with your immigrant background, and the fact that Princeton had just started allowing people of your background as students, how could you identify with a group that would discriminate against women and minorities?
Well, Diane Weeks was an assistant U.S. attorney in the U.S. Attorney's Office in New Jersey, and somebody that I hired, and one of many women whom I hired when I was U.S. attorney, and I think that illustrates my attitude toward equality for women. I've said what I can say about what I can recall about this group, Senator, which is virtually nothing. I put it down on the 85 form as a group in which I was a member. I didn't say I was anything more than a member. And since I put it down, I'm sure that I was a member at the time. But I'm also sure, and I have racked my memory on this, that if I had participated in the group in any active way, if I had attended meetings or done anything else substantial in connection with this group, I would remember it. And if I had renewed my membership, for example, over a period of years, I'm sure I would remember that. So that's the best I can reconstruct as to what happened with this group. I mentioned, in racking my memory about this, I said, what would it have been? What could it have been about the administration of Princeton that would have caused me to sign up to be a member of this group around the time of this application? And I don't have a specific recollection, but I do know that the issue of ROTC has bothered me for a long period of time. The expulsion during the time of the units at the time when I was a student there struck me as a very bad thing for Princeton to do.
Did women and minorities have anything to do with that?
No, and I did not join this group, I'm quite confident, because of any attitude toward women or minorities. What bothered me about the Princeton administration over a period of time was the treatment of ROTC. And after the unit was brought back, I know there's been a continuing controversy over a period of years about whether it would be kept on campus, whether in any way this was demeaning to the university to have an ROTC unit on campus, whether students who were enrolled in ROTC could receive credit for the courses, whether the ROTC instructors could be considered in any way a part of the faculty. All of this bothered me, and it is my recollection that it continued over a period of time.
Let me ask you, if I might, to reflect on a couple other things. You're a Bruce Springsteen fan?
I am, to some degree, yes.
Guess most people in New Jersey would be. They should be.
There was a movement some time ago. We don't have an official state song, and there was a movement to make Born to Run our official state song, but it didn't quite make it.
We'll stick with Lincoln in Illinois, but I can understand your commitment to Bruce Springsteen. They once asked him, how do you come up with the songs that you write and the characters that are in them? And he said, I have a familiarity with the crushing hand of fate. It's a great line. I want to ask you about the crushing hand of fate in several of your decisions. Riley versus Taylor. It was the murder conviction of an African-American defendant. And the question was raised as to whether he had a fair trial. And the people who were arguing in his defense said, when we take a look at the various people who were involved in these jury pools in the murder cases here, we find that the local prosecutors had eliminated all the African Americans in 4 murder trials that had taken place during the year that led up to his trial. And they raised the question in his case, whether there'd been a conscious effort to eliminate African American jurors, in this case involving an African American defendant. And you dismissed the statistical evidence of these all-white juries, and you made a statement that said the significance of an all-white jury was as relevant as the fact that, quote, 5 of the past 6 presidents of the United States have been left-handed, end of quote. That's a troubling analogy, and I'm not the only one troubled. Your colleagues on the Third Circuit were troubled as well. Here's what they said. The dissent, your dissent, has overlooked the obvious fact there's no provision in the Constitution that protects persons from discrimination based on whether they're right-handed or left-handed. To suggest any comparability to striking a jury based on their race is to minimize the history of discrimination against prospective black jurors and black defendants. Why did you use that analogy that apparently is so inappropriate?
Well, the analogy went to the issue of statistics and the use and misuse of statistics, and the fact that statistics can be quite misleading. Statistics are very powerful, but statistics can also be very misleading, and that's what that was referring to. There's a whole, statistics is a branch of mathematics, and there are ways to analyze statistics so that you draw sound conclusions from them and avoid erroneous conclusions from them. Sometimes when you see a pattern, it's the result of a cause, and sometimes when you see something that looks like it might be a pattern, it's the result of chance. Riley was a very, very difficult case, and I can tell you I struggled over that case because the issue of racial discrimination in the criminal justice system is an issue of enormous importance. Obviously, it's very important for the defendant. It's important for the society so that everybody knows that everyone in this country is treated equally, regardless of race. And it's important for law enforcement because I know from years as a prosecutor that nothing is a greater poison for law enforcement than even the slightest hint of unfairness. The issue of of racial discrimination in the jury had to be viewed by our court and by me under the habeas corpus statute that Congress passed. And that gave us an important role to play, but a very limited role. The Pennsylvania, and what the habeas corpus statute says is that if the state courts have decided a question on the merits and they've applied the correct legal standard, the correct constitutional standard, we can't authorize a granting of a writ of habeas corpus unless they were unreasonable. It's not enough for us to say we don't agree with it. We have to say you were unreasonable. Now, I think 7 members of the Pennsylvania judiciary, well, I think there were more. There was the judge who heard the state habeas case and the Pennsylvania Supreme Court. And the Pennsylvania Supreme Court, as I recall, was unanimous on the issue that there hadn't been racial discrimination in the selection of the jury in the case. Then the case came up to us, and the issue was whether the state courts were unreasonable in finding that the particular peremptory challenges at issue in this case were not based on race. And it was a tough question, but I didn't see how we could overturn what they had done under the habeas standard.
I just say, Judge, in many of these tough questions, as I read through your cases, you end up ruling in favor of established institutions and against individuals. Let me tell you another one, Paroli versus World Flavors. Remember this case? Mentally retarded individual, Kenneth Paroli, physically harassed at his workplace, subjected to a hostile, abusive work environment, sexually assaulted by his co-workers, and according to his deposition testimony, he said they attempted to rape him. I could read to you what's in that record here, but it is so graphic and it tells in such detail the sexual assault that he was subjected to that I'm not going to read it into the record, but I'll bet you remember it. And when it came to this case, as to whether or not he should have a trial, as to whether he was entitled to bring his case before a jury, you said no. Stand by the summary judgment. Don't take this to a jury. You dissented from the majority position here. And the reason you dissented was, I think, significant. It wasn't about Kenneth Paroli or the merits of his case. It was about the conduct and efforts of his lawyer. You noted the fact that his lawyer had not adequately provided citations in his brief to places in the record describing the harassment. So you held Kenneth Paroli responsible for the fact that his lawyer didn't do a good job and denied him, at least in your view, denied him his day in court. How do you explain that crushing hand of fate on this man who was a victim of sexual harassment?
Well, Senator, the district court thought that the defendant in that case was entitled to summary judgment, and so I think that says something about the facts of the case and whether it was a particularly strong case. There's a very important principle involved in the appellate practice, and I think it goes with the idea of judicial self-restraint. It is that certain things are to be decided at certain levels in the court system, and that requires that parties raise issues in the trial court, and that if they do not raise the issue in the trial court, then absent some extraordinary circumstances, they shouldn't be able to raise the issue on appeal. And that was the principle there. Now, this was not a criminal case. In a criminal case, there's a constitutional right to counsel, and so a person can claim ineffective assistance of counsel, and we treat that issue differently in criminal cases than we do in civil cases.
I would just say that you're arguing on the merits of the district court decision. Your statement in dissent criticized his lawyer for the brief that they presented to your court. That seems to me to be an unfair treatment of a man who I think deserved a day in court. Let me ask you about another group looking for a day in court. It's the RNS Services versus the Secretary of Labor case that I referred to in my opening statement. It's a timely case. It's about mine safety. We know what happened in West Virginia a few days ago and yesterday in the state of Kentucky, where there's serious questions being raised about whether there's adequate mine safety. And in this case, there was a question as to whether or not the federal and state mine safety provisions applied to a company in a certain activity. And you concluded they did not apply. You concluded that you would narrowly construe the statute passed by Congress, and in construing it in that way, that the requirements of inspecting this mine location, this treatment of coal, would not be subject to federal and state inspection. Again, when you dissented, and when given the chance, you ruled on the side of the company, on the side of the established institution, against the coal miners and against the workers in this circumstance. It's a recurring pattern. The crushing hand of fate here seems to always come down against the workers and the consumers and in favor of these established institutions and corporations. How would you explain the fact that you would so narrowly construe a statute when you knew that the lives and safety of coal miners were at stake?
And the facility that was involved in that case was not a mine as a layperson would think of a mine. It wasn't an underground facility. It wasn't like the facility in West Virginia where the terrible accident occurred a few days ago. It was basically a pile of coal that was being loaded onto trucks to be transported to another place. The definition of a mine under the federal law is very broad, and it's not limited to what ordinary people would think of as a mine. And there was an argument that this facility, which, as I said, as I recall, was basically a big pile of coal on top of the ground, and the coal was being hauled away to a cogeneration facility. Is that a mine? An ordinary person would look at that and say, that's not a mine, that's a pile of coal. But the issue in the case was the kind of technical issue of interpretation that we get all the time, and the question was, is this a mine in the sense of the law? And I thought it was not a mine in the sense of the law. Now, that conclusion, I don't believe, would mean that this facility would be spared safety regulation at either the federal or local level. It's been a long time since I worked on that case, but I would imagine that if the facility is not governed by the federal mining laws, it would be covered by OSHA, by the Occupational Safety and Health Administration, and perhaps by state law. So the issue would not be whether this facility would be allowed, which was not a mine in the ordinary sense, would be allowed to operate in an unsafe fashion. It was which body of laws and regulations would govern the facility.
Judge, I would say that your opinion did not prevail. The two other judges, both Reagan appointees, who saw this case on the side of the workers, understood that the wording of the law is as follows. Congress declares the first priority and concern of all in the coal or other mining industry must be the safety and health of its most precious resource, the miner. And instead of taking the obvious interpretation that these were people working in the mining industry, even if they were outside of the underground mine and the danger that it presents, you drew this statute as narrowly as you could, construed it as narrowly as you could, to take the company position here, that these federal and state, or in this case, the Federal Mine Safety Administration did not have jurisdiction. I find this as a recurring pattern, and it raises a question in my mind whether the average person, the dispossessed person, the poor person who finally has their day in court and may make it all the way through the process to the Supreme Court are going to be subject to the crushing hand of fate when it comes to your decisions. They have been many times at the Third Circuit, and that is a concern which I will continue when we have further questions in the next round. Thank you, Mr. Chairman.
Do you care to
Senator,
respond to Judge
yes,
Alito?
could I just say a couple of words? That case was a case of statutory interpretation and applying the statute, and that's how I thought it came out. There have been many other cases that I've worked on the Court of Appeals where I have come out in favor of the small person who was challenging a big institution. And I could mention a number of them. Let me just mention Shore versus Regional High School, because I think it has some relation to the Paroli case, which you mentioned. This was a case in which a high school student had been bullied unmercifully by other students in his school because of their perception of his sexual orientation. He'd been bullied to the point of attempting to commit suicide, and his parents wanted to enroll him at an adjacent public high school. And the school board said, no, you can't do that. And I wrote an opinion upholding their right to have him placed in a safe school in an adjacent municipality. I mean, that's just one example, but all of these cases involve what judges are supposed to do, which is to take the law and apply it to the particular facts of the case that is before them.
Thank you very much, Judge Alito. Senator Brownback.
Thank you very much, Mr. Chairman. Good morning, Judge Alito, Ms. Alito, family members. Good to have you here. I've got a number of areas I'd like to ask you questions about, and I'm hopeful we can get through them and maybe reduce the need of time in the second round, which would probably be to the pleasing to your ears. I want to first go at this area because it seems to keep coming up of that I think is really not applicable and not reflective of your record, that you always take the side of the big institution and against the little guy, as you just stated. But then I want to get into a number of areas of constitutional law, some of which that you've written on, religious freedom type cases, takings cases. I'd like to get into some of these areas. But I want to enter into the record, Mr. Chairman, a letter from a former law clerk of yours, David Walk, dated January 6, 2006. David worked with you in New Jersey U.S. Attorney's Office. I believe you, I don't know if you remember David or not.
I do. He was a
Without objection, it will be made a part of the record.
Thank you. He's a lifelong Democrat, former member of the ACLU, and talks about how fair you were to everybody's rights. But then he cites the case of Franklin Igbanwa. This was a Nigerian set to be deported for drug dealing, who had testified against other Nigerian drug dealers and was fearful of being deported, that he would be killed once back in Nigeria. The other two judges said his case, he shouldn't be believed on the face of it, and you said he should, and that the trial court should have given more deference to this Nigerian to be deported. This was somebody that David Walk represented. Talk about a little guy in a case, and that's one that's cited in this particular record and letter that I would hope my colleague from Illinois could take a chance at, because it's a legitimate point of view that's saying, well, it looks like you always take one side or the other. Here's where another side was taken. And then here's a letter from another individual who worked with you, Kathy Fleming, lifelong Democrat, President-elect National Women's Bar Association, gives an unqualified endorsement of you. And she says, but by providing my credentials as an outspoken women's rights advocate and liberal-minded criminal defense attorney, I hope you will appreciate the significance of my unqualified and enthusiastic recommendation of Sam Alito for the Supreme Court. I think one can kind of look in the past and try to say, well, okay, there's this problem, there's that, but then when people that know you well put their names to letters saying differently, I think that's also something we should consider, and I'd ask that that letter be put into the record as well.
Without objection, it will be made a part of the record.
Thank you. Judge Alito, the Supreme Court has gotten a number of things wrong at times, too. That would be correct, and the answer when the court gets things wrong is to overturn the case. That's the way it works, isn't that correct?
Well, when the court gets something wrong and there's a prior precedent, then you have to analyze the doctrine of stare decisis. It is an important doctrine, and I've said a lot about it. But
let me just ask you: was Plessy wrong? Plessy versus Ferguson.
Plessy was certainly wrong.
Okay, I mean, and you've gone through this. Brown versus Board of Education, which is in my hometown of Topeka, Kansas. I was there last year at the dedication of the schoolhouse 50 years ago. That overturned Plessy. Plessy had stood on the books since 1896. I don't know if you knew the number, and I've got a chart up here. It was depended upon by a number of people for a long period of time. You've got it sitting on the books for 60 years, twice the length of time of Roe versus Wade. You've got these number of cases that considered Plessy and upheld Plessy to the dependency. And yet Brown comes along, 1950s case, poor little girl has to walk by the all-white school to go to the black school in Topeka, Kansas. And the court looks at this and they say unanimously, that's just not right. Now, stare decisis would say in the Brown case you should uphold Plessy. Is that correct?
It was certainly would be a factor that you would consider in determining whether to overrule it.
But obviously,
Doctrine that you would consider.
Obviously, Brown overturned it, and thank goodness it did, correct?
Certainly.
That it overturned all these super-duper precedents that had been depended upon in this case because the court got it wrong in Plessy. Is that correct?
The court certainly got it wrong in Plessy, and it got it spectacularly wrong in Plessy, and it took a long time for that erroneous decision to be overruled. One of the things I think that people should have understood that separate facilities, even if they were absolutely equal in every respect, even if they were identical, could never give people equal treatment under the law. I think they should have recognized that. But one of the things that was illustrated in those cases, and Sweat versus Painter, the last one on the list, brought that out, was that in fact the facilities, the supposedly equal facilities, were never equal, and the continuing series of litigation that was brought by the NAACP to challenge racial discrimination illustrated. If the illustration was needed, the litigation illustrated that in fact the facilities that were supposedly equal were not equal. And that was an important factor, I think, in leading to the decision in Brown versus Board of Education.
I want to give you another number, and that is that in over 200 other cases, the court has revisited and revised earlier judgments. In other words, in some portion or in all the case, the court got it wrong in some 200 cases. And thanks goodness the court's willing to review various cases. I want to give you an example of a couple, though, that the court hasn't reviewed yet that I think are spectacularly wrong. 1927 case of Buck versus Bell. I don't know if you're familiar with that case. The court examined a Virginia statute that permitted the sterilization of the mentally impaired. Gary Buck, a patient at the so-called Virginia State Colony for Epileptics and Feeble-Minded, was scheduled to be sterilized after doctors alleged she was a genetic threat to the population due to her diminished mental capacity. Buck's guardian challenged the decision to have Carrie sterilized all the way to the Supreme Court, but in an 8-to-1 decision, the court found that it was in the state's interest to have her sterilized. Majority opinion written by Justice Oliver Wendell Holmes said, "We have seen more than once that the public welfare may call upon the best citizens for their lives. It would be strange if it could not call upon those who already sap the strength of the state for these lesser sacrifices, often not felt to be such by those concerned, in order to prevent our being swamped with incompetence." Clearly, some precedences are undeserving of respect because they're repugnant to the Constitution. Aren't they? Isn't Plessy repugnant to the Constitution?
It certainly was repugnant to the Equal Protection Clause.
And the vision of human dignity, isn't Buck and those sort of statements by Oliver Wendell Holmes repugnant to the Constitution?
I think they are repugnant to the traditions of our country. I don't think there's any question about that.
I'll give you another case, the Korematsu case versus the United States. 1944 case. World War II broke out following Japanese attacks on Pearl Harbor. Feelings spread that Japanese Americans, both naturalized and those born in the United States, might not be loyal to the United States, should be removed from the West Coast. So great was the fear that even the esteemed writer Walter Lippmann stated that, quote, "Nobody's constitutional rights include the right to reside and do business on a battlefield. There's plenty of room elsewhere for him to exercise his rights." President Roosevelt signed an executive order removing them. Korematsu contested the constitutionality, Fred Korematsu did, of his internment. In Korematsu versus the United States, Supreme Court held that military necessity justified the internment program, and then Fred Korematsu had no protection against relocation under the Constitution. Of course, that was later overturned. Excuse me, that was never overturned. 1948, Congress enacted Japanese American Evacuation Claims Act to provide some monetary compensation. 1980, Congress again revisited the case. 1988, Congress passed legislation apologizing for the internment, awarded each survivor $20,000. 1999, Fred Korematsu was awarded the Presidential Medal of Freedom, highest civilian honor that anyone can receive. Justice has not been done because Korematsu remains on the books. Still on the books. Roe versus Wade. You've had every question on that. But I want to point out its difficulty. My colleagues on the other side look at this as completely settled law, but let's see what the legal experts say about how settled it is. Lawrence Tribe will be here to testify, I believe, probably against you in a little bit. Let's see what he says, professor of law at Harvard. quote, "One of the most curious things about Roe is that behind its own verbal smokescreen, the substantive judgment on which it rests is nowhere to be found. Settled law? Super-duper precedents?" Orange Tribe has some questions about it. Justice Ruth Bader Ginsburg. "Roe, I believe, would have been more acceptable as a judicial decision if it had not gone beyond a ruling on the extreme statute before the court. Heavy-handed judicial intervention was difficult to justify and appears to have provoked, not resolved conflict." Provoked, not resolved conflict, one of your potential colleagues says. Edward Lazarus, former clerk to Chief Justice Harry Blackmun, who wrote Roe. "As a matter of constitutional interpretation and judicial method, Roe borders on the indefensible. I say this as someone utterly committed to the right to choose, as someone who believes such a right was grounded elsewhere in the Constitution instead of where Roe placed it, and as someone who loved Roe's author like a grandfather." Settled law? Edward Lazarus has some questions about it being settled. Let's look at John Hart Ely, former dean, Stanford Law School, excellent law school in the country, one of the top law schools in the country. "Roe versus Wade, quote, is not constitutional law and gives almost no sense of an obligation to try to be. What is frightening about Roe is that this super-protected right is not inferred from the language of the Constitution, framers thinking respecting the specific problem issue, any general value derivable from the previous provisions they included, or the nation's governmental structure." John Hart Ely. He thinks Roe is settled law, not constitutional, gives no sense of an obligation to try to be. Alan Dershowitz, professor of law, Harvard Law School, one of the top law schools in the country. It's not Princeton, but Roe versus Wade and Bush versus Gore, quote, represent opposite sides of the same currency of judicial activism in areas more appropriately left to the political process. Judges have no special competency, qualifications, or mandate to decide between equally compelling moral claims. As in the abortion controversy, clear governing constitutional principles are not present in either case. Settled law? Super-duper precedents? I think there's places where the court gets it wrong, and hopefully they will continue to be willing to revisit it. Now, I want to look at a couple of areas of law in addition to this. Your view of the Constitution, and we had yesterday, you hit at this, I thought, on some of the edges, but I just want to get your thoughts of how you view the Constitution, how you would review it. There are these different schools of thought on this, of strict constructionist, living document, originalist, and there are several others that float around out there. How do you generally look at the Constitution? And I'm aware yesterday you were saying that some provisions are very clear and some are not, and you seem to apply a different set of viewpoints on those of the Constitution. Could you articulate your view of how you look and interpret the Constitution?
First of all, Senator, I think the Constitution means something, and I don't think it means whatever I might want it to mean or whatever any other member of the judiciary might want it to mean. It has its own meaning, and it is the job of a judge, the job of a Supreme Court justice, to interpret the Constitution, not distort the Constitution, not add to the Constitution or subtract from the Constitution. In interpreting the Constitution, I think we should proceed in the way we proceed in interpreting other important legal authorities, in interpreting statutes. For example, I think we should look to the text of the Constitution, and we should look to the meaning that someone would have taken from the text of the Constitution at the time of its adoption. But I think we have to recognize that the Constitution is very different from statutes in some important respects. Statutes are often very detailed, and they generally don't exist without revision for very long periods of time. The Constitution was adopted to endure throughout the history of our country, and considering how long our country has existed, it's been amended a relatively few times. And the magic of that, I think, is that it sets out a basic structure for our government and protects fundamental rights. But on a number of very important issues, I think the framers recognized that times would change, new questions would come up, And so they didn't purport to adopt a detailed code, for example, governing searches and seizures. That was the example I gave yesterday, and I'll come back to it. They could have set out a detailed code of search and seizure. They didn't do that. They said that the people are protected against unreasonable searches and seizures, and they left it for the courts, and of course the legislative body can supplement this, to apply that principle to the new situations that come up. Now that doesn't, when that is done, that doesn't amount to an amendment of the Constitution or a changing of the Constitution. It involves the application of a constitutional principle to the situation at hand.
Let me go to a specific area you've written quite a bit about, and that's on religious liberties and free exercise. And I've looked at these cases. You've got, and this is going to be an active area of law in front of the Supreme Court. It has been for the last 40 years. You wrote the case of ACLU versus Schindler, Third Circuit case considered, it's ACLU challenge to religious displays erected by Jersey City on the plaza of City Hall. Jersey City for decades had had holiday displays of menorah and Christmas tree. Litigation resulted in permanent pulling of this. The city came back and said, okay, if that's not good enough, we'll put a nativity scene, a menorah, a Christmas tree, Frosty the Snowman, Santa Claus, Kwanzaa symbols, and signs explaining the display. So, okay, if two's not enough, we'll add more into it. And they were again challenged by the ACLU. District Court found no constitutional violation. Panel Third Circuit, not including you, reversed that decision. Panel found no basis for the demystification approach, as they put it, and expressed skepticism as to constitutional display. On remand, District Court held that there was a constitutional violation. City appealed. You said on the panel that heard that appeal in a 2-1 decision, you upheld the constitutionality of the modified display. In your decision, you specifically cited Justice O'Connor and two particular issues regarding excessive entanglement with religious institutions and government endorsement or disapproval of religion. Because Justice O'Connor used these factors to uphold similar displays in prior cases, you applied them to your upholding in that case. That's a correct interpretation. Is that correct?
Yes, it is, Senator.
Because these are coming up so much in front of the court, are these types of display you feel generally constitutionally permissible?
Well, this is an area in which the Supreme Court has handed down several decisions, and like a number of the issues that the court has addressed under the Establishment Clause, it has drawn some fairly fine lines. The first case involving a display of this nature was the Pawtucket, Rhode Island display that was involved in Lynch versus Donnelly. And it was a display that was similar to the display in Jersey City. It included both religious and secular symbols, and they found that was not a violation.
I want to jump here because I've got several areas I want to go at. When I read your opinions, what I hear you to write is you would rather have a robust public square than a naked public square, that you think there is room for these sorts of displays in the public square.
Well, that was exactly what Jersey City had decided in that case. And Jersey City said, we are one of the most religiously diverse, ethnically diverse, racially diverse communities you will find anywhere in the country. This is right across the New York Harbor from the Statue of Liberty and from Ellis Island, and it's still an entry point for a lot of people coming into the country. And so they had, over the course of the year, at the appropriate time, they had a Christmas display. They had a display of a menorah. On that particular year, Hanukkah was early in the month of December, so the menorah was up at a different point. They had a display. They had celebrations for Muslim festivals, for Hindu festivals, for Buddhist festivals, for Latino festivals, for festivals concerning the many ethnic groups in the community. And their view was that this is the way we should show that all of these groups are valuable parts of our community and express our embracing of them. And this display, they said, reflected that philosophy and applying the precedents that the Supreme Court had provided in this area, the Pawtucket case, and a later case involving a display in Pittsburgh. Judge Rendell and I, who were the judges in the majority on that case, said this is constitutional. This is consistent with the Establishment Clause.
Well, and that's what, as we've had this 40 years of cases, I really hope we can have a public square that celebrates and not it's got to be completely naked to be able to use, and I appreciate that. You wrote in a free exercise case, CH versus Olivia, heard case against a child was sued, in which a child sued through his parents for violation of his free speech and free exercise rights when his school removed and repositioned a poster he had made of a religious figure that was important to him. This picture of Jesus. The poster was part of an assignment which students were instructed to show something for which they were thankful. District Court granted judgment on the pleadings in favor of the defendant, the school district. Third Circuit affirmed. You dissented in that opinion. Can you elaborate on your reasoning in that particular opinion? Remember the case?
Yes, Senator, I do. Justice O'Connor pointed out something that's very critical in this area. She said there is a big difference between government speech endorsing religion and private religious speech. And this case and private religious speech can't be discriminated against. It has to be treated equally with secular speech. And in this case, this involved a student who, and there were two incidents. One involved reading. The students in the class were told that if they could read at a certain level, they would have, their reward would be to be able to read their favorite story to the class. And this student satisfied those requirements, and the student wanted to read a very simplified version of the story of Jacob and Esau to the class. And the teacher said, no, you can't read that. You can, to the class, you can read that privately to me off in a corner. And then Thanksgiving was coming along, and the students were told you can draw a picture of something that you're thankful for. And I guess the teacher expected they were going to draw pictures of football games and turkeys and things like that. But this student drew a picture of Jesus and said, that's what I'm thankful for. And the teacher put all the other pictures up in the hall, but would not put this student's picture up in the hall because of its religious content. And that, we found, was a violation of this principle that you have to treat religious speech equally with secular speech. If you ask a student to say something about a topic, what are you thankful for, and the student says something that fits within the topic that the student was asked to talk about, then you can't discriminate against one kind of speech or another.
I thought it was a very interesting stance, and I think appropriate, that you took, and in one of the obviously very active areas of the law that we have. We'll look at the issue of checks and balances on the federal court. It's a very active area here in Congress, as a lot of people across the country and certainly members of Congress have grown the feeling that we can rule however, we can do whatever we want to here, but wait till the court decides that the court is moved beyond judicial restraint. I asked this of John Roberts, and I asked, what's the checks and balances on Congress are obvious. President can veto a bill. The court can declare something unconstitutional. Checks and balances, executive branch are clear. They can be challenged their actions in the court. Court can say the president can't do that. We cannot appropriate the money from here. We've got checks and balances, and people are well known. Any high school government student would know that. Checks and balances on the court. When I talked to John Roberts about this, he said basically the only check and balance is judicial restraint. It's what the court restrains itself in. And yet you have within the Constitution a provision that is there that I asked him about that I want to ask you about. Article 3, Section 2 goes, in all cases, in all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact. Then it goes on with this interesting exceptions clause, with such exceptions and under such regulations as the Congress shall make. Last phrase known as the exceptions clause. What do you believe is Congress's power to define the jurisdiction of the Supreme Court under the Exceptions Clause?
Well, the Exceptions Clause obviously gives Congress the authority to define the appellate jurisdiction of the Supreme Court, and it can provide for various avenues by which cases get to the Supreme Court, and that has changed over the years. There's been a controversy, never resolved, about the exact scope of the authority. It came up in Ex parte McCardle in the post-Civil War era, and it has been raised it has been discussed by scholars in subsequent years, and there are several schools of thought on the question about whether it would be consistent with the Constitution for Congress to eliminate jurisdiction in the Supreme Court over a particular type of case. That's an unresolved issue that the scholars have addressed, and some argue that that falls within the Exceptions Clause, and some argue that it would be inconsistent with other provisions of the Constitution.
What I see taking place in this country as the court gets more and more involved in tough political issues is you're going to be pressing other bodies then to say, look, we believe these decisions should be here. We believe the issues on the competing interest in abortion, the mother and the child, should be decided by legislative bodies. But the court said no. Issue of marriage is coming through the courts system right now. As the court keeps getting involved in these areas, I think you're going to see these sorts of constitutional issues being explored more and more. Marriage case I want to take you to, because that's making its way through the federal court. 45 of our 50 states have deemed marriage being between the union of a man and a woman. The state of Nebraska passes a state constitutional amendment, 70% of the people voting for it, saying that marriage is the union of a man and a woman. Yet a federal judge in that case threw out the state constitutional amendment on novel constitutional grounds, and it's now making its way up through the system. The Congress has passed the Defense of Marriage Act, DOMA, passed overwhelmingly, signed into law by President Clinton, basically did two things. First, establishes for purposes of federal law, marriage would be defined as a union of a man and a woman, and second, to provide that no state would be forced to recognize a marriage entered into in another state. A number of legal scholars believe that this second part violates the full faith and credit clause of the Constitution. Judge Alito, this case is coming forward and will probably be resolved in the federal courts if it isn't resolved by the Congress through a constitutional amendment. What's your understanding of the meaning of the full faith and credit clause, and does this apply to the institution of marriage, which has been traditionally an issue in an area left up to the states?
Well, several constitutional doctrines seem to be implicated by the matters that you discussed. The full faith and credit clause in general means that one state must honor judgments that are issued by a court of another state. And it's an important part of the process. It is an important part of the federal system, so that we don't have warring decisions in different states. It is not I have not had cases involving this, but the doctrine has certain boundaries to it. There are exceptions, and it covers certain areas and doesn't cover other areas. And a challenge to the Defense of Marriage Act under the full faith and credit clause would call into question the precise scope of the doctrine. And I believe that scholars have expressed differing views about how it would apply in that situation, and that's an issue that may well come up within the federal courts, almost certain to do so.
Almost, yeah. And I know you can't express on it. One last thing I'd like to get into just very briefly is the takings clause in the Kelo case. It was in a neighboring circuit to yours, Kelo versus City of New London, where private property was taken by a another private group. Private property was taken by a public group and given to another private group. Judge O'Connor wrote eloquently in her dissent, "Nothing is to prevent the state from replacing any Motel 6 with a Ritz-Carlton, or any home with a shopping mall, or any farm with a factory now." I just conclude by putting that in front of you, saying that this is one that people have relied upon for a long time. You couldn't take private property to another private individual. It's for public use. And I hope that's one that the court will end up reviewing at some point in time. Thank you, Mr. Chairman.
Thank you, Senator Brownback. Senator Coburn.
Thank you, Mr. Chairman, and good morning. Long day. I'd like to put a few things into the record, if I may. One is just a list of cases where Judge Alito ruled for the little guy. There's been a lot made, and here's a list of 9 cases with specifics where he, in fact, one of these I think he mentioned, but the others, and I'd like unanimous consent.
Without objection, they will be made a part of the record.
Cases. And I also want to go back and quote from somebody who was a member of CAP, and this is Judge Napolitano. He's a commentator on one of the news shows, and I'd like his statements put into the record from yesterday, where he clarified what CAP was about and clarified the interest of ROTC, ROTC, on at Princeton, and the fact that that was one of the leading reasons that that organization was formed. So I'd like for those to be admitted as well. As you know, I'm not an attorney. Sometimes it's very disadvantageous on this panel, but at times it's advantageous. So I have this little thing that I have to depend on, and I kind of read it for what it says. And as you talk about stare decisis, is that mentioned anywhere in here?
It is not expressly mentioned in the Constitution.
It's actually a procedure of common English law, correct?
That's its origin, yes.
That's its origin, and we use that as a tool for working with the Constitution. Can you recall the number of times that precedents have been reversed by the Supreme Court?
I don't know the exact figure, Senator.
I think it's around 170-some times, affecting some 225 cases. I believe that's close. That may not be exactly accurate. So in fact, it's a tool used to help us with the law, but our founders didn't say you have to use stare decisis in this, did they?
No, they didn't. They conferred the judicial power on the judiciary, and I think that contemplated that the federal judiciary would be permitted to proceed in accordance with fundamental judicial procedures as they had been known
at the time.
At the time.
That's right. And Article 3, Section 2 really delineates the scope for the courts in this country. And what it says is all cases in law and equity arising under this Constitution, the laws of the United States and treaties made or which shall be made under their authority. So that really gives us the scope under Article 3, Section 2. And I was interested in Senator Kyle asked you yesterday about foreign law. It's something that is extremely disturbing to a lot of Americans, that many on the Supreme Court today will reference or pick and choose the foreign law that they want to use to help them make a decision to interpret our Constitution, where in fact the oath of office mentions no foreign law. Matter of fact, it says the obligation is to use the United States law, the Constitution, and the treaties, and that's exactly what Article 3, Section 2 says. And so there's no reference at all to foreign law in terms of your obligations or your responsibility. And matter of fact, the absence of it would say that maybe this ought to be what we use, and the codified law of the Congress and the treaties rather than foreign law. So the question I have for you, and I couldn't get Judge Roberts to answer it because of the conflict that might occur afterwards, but I have the feeling that the vast majority of Americans don't think it is proper for the Supreme Court to use foreign law. And I personally believe that that's an indication of not good behavior by a justice, whether it be a justice at an appellate division or a magistrate or a Supreme Court justice. And I just wondered if you had any comments on that comment.
Well, I don't think that we should look to foreign law to interpret our own Constitution. I agree with you that the laws of the United States consist of the Constitution and treaties and laws, and I would add regulations that are promulgated in accordance with law. And I don't think that it's appropriate or useful to look to foreign law in interpreting the provisions of our Constitution. I think the framers would be stunned by the idea that the Bill of Rights is to be interpreted by taking a poll of the countries of the world. The purpose of the Bill of Rights was to give Americans rights that were recognized practically nowhere else in the world at the time. The framers did not want Americans to have the rights of people in France or the rights of people in Russia or any of the other countries on the continent of Europe at the time. They wanted them to have the rights of Americans, and I think we should interpret our Constitution. We should interpret our Constitution. I don't think it's appropriate to look to foreign law. I also don't think that I think that it presents a host of practical problems that have been pointed out. You have to decide which countries you're going to survey, and then it's often difficult to understand exactly what you are to make of foreign court decisions. All countries don't set up their court systems the same way. Foreign courts may have greater authority than the courts of the United States. They may be given a policy-making role, and therefore it would be more appropriate for them to weigh in on policy issues. When our Constitution was being debated, there was a serious proposal to have members of the judiciary sit on a council of revision where they would have a policy-making role before legislation was passed, and other countries can set up their judiciary in that way. So you'd have to understand the jurisdiction and the authority of the foreign courts. And then sometimes it's misleading to look to just one narrow provision of foreign law without considering the larger body of law in which it's located. That can be, if you focus too narrowly on that, you may distort the big picture. So for all those reasons, I just don't think that's a useful thing to do.
It actually undermines democracy because you get to pick and choose. And the people of this country don't get to pick and choose that law. It's people from a different country. So it actually is a violation of the Constitution. And it, to me, very strongly and adamantly feel that it violates the good behavior which is mentioned as part of the qualifications and the maintenance of that position. I'm sorry Senator Durbin left. I wanted to razz him a little bit. You know, you've taken quite a bit of criticism on what things that you've written and said in 1985, but I want to put forward for 45 years, Senator Durbin was adamantly pro-life, and he wrote multiple letters expressing that up until 1989. He's a very strong advocate for the abortion stance and free right to choose, but I think it's important that the American people is, if he has the ability to change his mind on something he wrote in 1989, certainly you have the ability to say something was inaptly put. And so this is just Senator Durbin. I'm teasing him a little bit, but I think it's important that people recognize people can change their mind. I continue to believe the Supreme Court's decision in Roe v. Wade should be reversed. There are other members on the other that are adamantly pro-abortion, pro the destruction of human life today that have changed their mind, changed their position. So it's hard to be critical of you in something in 1985, have written something when many of us have backtracked on things that we've said through the years. And so I think it puts a little bit of perspective into where we're going. I want to spend just a minute, if I can. Yesterday, during Senator Feinstein's question, there was some discussion about the health exception to any regulations pertaining to abortion. And on January 22nd, when Roe was decided, the court also decided Doe v. Bolton. And in that case, the court ruled that a woman's right to abortion could not be limited by the state if abortion was sought for reasons of maternal health. And as a practicing physician, I agree with that. I've actually performed abortions on women who were going to die if they did not have an abortion. So the choice was is somebody alive versus losing both. The court defined health as all factors, physical, emotional, psychological, familial, and the woman's age, relevant to the well-being of the patient. This exception effectively expanded the right to abortion for any reason through the entire pregnancy. Since that time, states have been trying to find ways to effectively regulate abortion without intruding on this health exception, but it's proven nearly impossible. And, you know, the absence of knowledge is something that Roe v. Wade, which I believe was wrongly decided, has hurt us immensely in this country. And the absence of informed consent on abortion has hurt us immensely. And, Mr. Chairman, I'd like to enter into the record a study published, a 35-year longitudinal study, which was just released this January from New Zealand, that followed women, 600 women for 35 years from the time of the abortion, that studied the ill health effects
Without objection, it will be made a part of the record.
I'd also like to enter into the record a Breast Cancer Institute study and analysis of a Lancet 32504 article, and also the testimony of Dr. Elizabeth Shadigan, University of Michigan Clinical Associate Professor, Department of Obstetrics and Gynecology, as to the complications.
All of those documents, without objection, will be made a part of the record.
It's amazing what we don't know, and as I explained in my opening statement, once we go down a path, the complications associated, the rulings that you make have major impact. I understand the questions that you cannot answer on things that are going to come before us, and I can't pretend to know what is in your heart about those issues. But what I do know is you were pretty aggressively approached on positions in terms of Justice O'Connor and executive power. And there seemed to be a blinding contradiction during some of your questions you presented, that were presented by my colleagues yesterday. They raised concerns that you're too close to the executive and too supportive of executive power. They wanted to be sure that you respect the role of the judiciary and free from the influences of the political branches. However, they then argue that you should have the same ideology as Justice O'Connor to maintain the balance on the court. I have trouble figuring out how they can have it both ways. That's an inherently political desire. Is there anything in the Constitution, this little document, that says what the ideology ought to be of one Supreme Court justice replacing another one?
The Supreme Court simply gives the president the authority to nominate justices of the Supreme Court and other federal judges, and gives Congress the advice and consent responsibility, and doesn't go further than that.
And the president, by being elected, the only person in this country that's elected by the whole country, is given that honor and that privilege as well as that responsibility, and then we have the responsibility to advise and consent to that. Is that correct?
That's correct.
But nowhere in the Constitution, nor by precedent, matter of fact, the precedent's just exactly the opposite of that, is it stated that somebody has to have the same philosophy as somebody that's coming off the court.
I think that every Supreme Court justice is an individual. I think every nominee is an individual, and no nominee can ever be a duplicate of someone who retires, and particularly when someone retires after such a distinguished career and such a historic career as Justice O'Connor. Nobody can be expected as a nominee to fit that mold.
So the fact that you have to fit Sandra Day O'Connor mold is really a misapplication of it. There is no precedent that would say that.
The only, if I'm confirmed, I'll be myself. I'll be the same person that I was on the Court of Appeals. That's the only thing that I can say in answer to that.
Let me repeat some facts that one of my colleagues mentioned yesterday. Of the 109 justices to sit on the Supreme Court, nearly half have replaced justices appointed by another political party. President Clinton replaced Justice White, who dissented on Roe v. Wade, with Justice Ginsburg, who argued for a right to abortion. Justice Ginsburg was, I think, 3 votes against her in the Senate when she was approached, and she took it completely opposite, but she was well qualified. She had integrity, and she was voted onto the court even though many people knew that her philosophy was very different than theirs. Isn't that true?
She was, the vote was 90-something to a small number. I know that, yes.
I want to get, a lot of times in these hearings, you don't get a chance to say, why would you want to be a justice of the Supreme Court of the United States? Why would you want that responsibility? Why do you want to go through this process to be able to achieve that position? Can you tell the American people why?
I think it's a chance to make a contribution. I think it's a chance to use whatever talent I have in the most productive way that I can think of. There are a lot of things that I can't do. There are a lot of things that I couldn't do very well if I was given the assignment of doing them. But I've spent most of my career as an appellate attorney. I spent most of my career before becoming a judge as an appellate attorney, and now I've spent 15 years as an appellate judge. And I think this is what I do best, and I think this gives me an opportunity to make a contribution to the country and to the society, because the Supreme Court has a very important role to play, and it's important that it do the things that it's supposed to do well, and I would do my very best to further that. And it is also important for the Supreme Court, and for that matter, all of the federal courts, to exercise restraint. And as you were referring to earlier, that has turned out to be the principal check on the way the judiciary does its work on a day-to-day basis. The judiciary is not checked in its day-to-day work in the same way as the Congress and the President. The Congress can pass a law, can pass a bill, and the President can veto it. One house can pass a bill, the other house may not go along. The President has to propose legislation to Congress. If the President wants legislation, Congress can pass laws that the President doesn't like. There are checks and balances that are worked out in the ordinary processes of government. But when it comes to the judiciary, in deciding constitutional cases, the judiciary is checked on a daily basis, primarily by its own discipline, its own self-restraint. And so it's important for the judiciary has these twin responsibilities that are in tension at times, doing what it is supposed to do and doing those things well and vigorously and courageously if it comes to that, but at the same time constantly monitoring its own activities and asking, are we doing what we are supposed to be doing as judges? Are we functioning as judges, or are we stepping over the line? Are we turning ourselves into legislators? Are we turning ourselves into members of the executive branch or administrators? And the judiciary has to maintain its independence. That's of critical importance, and that's an important part of the role. And that also has to be informed by this sense of self-restraint.
Thank you. During Judge Roberts' hearing, Senator Feinstein tried to get him to talk and speak out of his heart, and I thought it was a great question. So that American people can see your heart. This booklet's designed to protect the weak, to give equality to those who might not be able to do it themselves, to protect the frail, to make sure that there is equal justice under the law. I think at times during these hearings you've been unfairly criticized or characterized as that you don't care about the less fortunate, you don't care about the little guy, you don't care about the weak or the innocent. Can you comment just about Sam Alito and what he cares about, and let us see a little bit of your heart and what's important to you in life.
Senator, I tried to, in my opening statement, I tried to provide a little picture of who I am as a human being and how my background and my experiences have shaped me and brought me to this point. I don't come from an affluent background or a privileged background. My parents were both quite poor when they were growing up, and I know about their experiences, and I didn't experience those things. I don't take credit for anything that they did or anything that they overcame, but I think that children learn a lot from their parents, and they learn from what the parents say, but I think they learn a lot more from what the parents do and from what they take from the stories of their parents' lives. And that's why I went into that in my opening statement, because when a case comes before me involving, let's say, someone who is an immigrant, and we get an awful lot of immigration cases and naturalization cases, I can't help but think of my own ancestors, because it wasn't that long ago when they were in that position. And so it's my job to apply the law. It's not my job to change the law or to bend the law to achieve any result, but I have to, when I look at those cases, I have to say to myself, and I do say to myself, you know, this could be your grandfather, this could be your grandmother. They were not citizens at one time, and they were people who came to this country. When I have cases involving children, I can't help but think of my own children, and think about my children being treated in the way that children may be treated in the case that's before me. And that goes down the line. When I get a case about discrimination, I have to think about people in my own family who suffered discrimination because of their ethnic background or because of religion or because of gender. And I do take that into account. When I have a case involving someone who's been subjected to discrimination because of disability, I have to think of people who I've known and admired very greatly who've had disabilities, and I've watched them struggle to overcome the barriers that society puts up, often just because it doesn't think of what it's doing, the barriers that it puts up to them. So those are some of the experiences that have shaped me as a person.
Thank you. Mr. Chairman, I think I'll yield back the balance of my time at this time, and if I have additional questions, we'll get them in the next round.
Thank you very much, Senator Coburn. We'll now proceed to the second round of questioning, with each senator having 20 minutes, and we'll take 20 minutes more, and then we'll take the break. Is it appropriate for the court to declare acts of Congress unconstitutional because of our, quote, method of reasoning? Does the court have some superior insights on a method of reasoning? Is it appropriate for the court to declare acts of Congress unconstitutional, functioning as a taskmaster to make sure that Congress does its homework? There have been a series of decisions which have seriously undercut congressional power, where, in my opinion, the court has usurped the authority of Congress. And this moves into the often criticized range of congressional legislation and judicial legislation in derogation of the congressional power. We are seeking, Judge Alito, to have an appropriate equilibrium in our system, and the beauty of the American system is that no one has too much power. We call it separation of power, although not specifically mentioned in the Constitution. We call it checks and balances. We've looked into the issue of tremendous importance. Regrettably, we haven't plumbed it, only scratched the surface, but our time is limited on the authority of the President under War Powers, Article 2, contrasted with Congress's authority to legislate for privacy under the Foreign Intelligence Surveillance Act. And I want to move into two other analogous areas, Congress versus the court, and the court versus Congress, as Congress has taken away the jurisdiction of the court, notably very recently by stripping habeas corpus jurisdiction on detainees. When the Congress legislated to protect women against violence, the Congress did so with a very expansive record. It wasn't like Lopez, which was a revolution where the court upset 60 years of congressional power into the Commerce Act, but in the case of U.S. versus Morrison involving the legislation to protect women against violence, there was a record which included gender bias from task forces in 21 states, 5 separate reports. And notwithstanding a, quote, mountain of evidence, as noted by 4 dissenters, the court declared the act unconstitutional because of our method of reasoning. Now, you're a judge. You may be a Supreme Court justice. Is there something we're missing? Do you judges have some method of reasoning which is superior to the method of reasoning of the Congress?
I think the branches of government are equal, and everybody, all the officers in all the branches of government take an oath to the same Constitution.
Equality on method of reasoning?
I would never suggest that judges have superior reasoning power than does Congress. I think what the court was getting at when it made that statement in Morrison, and yesterday I looked at something that I had written and said that was not well phrased. I think that what the court was getting at there in Morrison was that it was applying a certain standard, a certain legal standard as to whether something substantially affected commerce, and I think that's what they were getting at. But
hard to figure out what they were getting at. We do know what they said. They said our method of reasoning was defective, but I take it from your statement you wouldn't subscribe to overturning congressional acts because of our method of reasoning.
I think that Congress's ability to reason is fully equal to that of the judiciary, and I think
And you think that even after appearing here for a day and a half?
I have always thought that, and nothing has changed my mind about that.
Starting to worry about you.
That's on Senator Hatch's time. Let me take up the Americans for Disability Act on 2 decisions within a couple of years of each other, one where the Supreme Court declared unconstitutional the Americans for Disabilities Act as it applied to employment, upholding the act as it applied to access to facilities. And Justice Scalia had a ringing dissent when the court imposed a standard of congruence and proportionality, a very difficult standard which you wrestled with in the family leave case. The congruent and proportionate standard came to the court in the Bernie case in 1997, so it is very, very recent origin, and it has all the earmarks of having been pulled out of the thin air. And Justice Scalia said that it was a thinly veiled, an invitation to judicial arbitrariness and policy-driven decision-making. And Justice Scalia criticized the majority opinion for functioning as a taskmaster to see to it that Congress had done its homework. And here again, there was a voluminous record, 13 congressional hearings, 30,000 people were surveyed. Do you think, Judge Alito, that a test like congruence and proportionality is fair notice to the Congress on what we can do by way of legislation? Here we're dealing, and it's maybe worthy just a little explanation. When Congress legislates on constitutional issues under Article 5 of the 14th Amendment, the court then makes a comparison to state immunity under the 11th Amendment. But do you think that's a fair test as to what we're to try to figure out what the Supreme Court is later going to say is congruent and proportionate?
Well, like many tests in the law, it is not a mathematical or a scientific formula that can produce a particular result with certainty as it is applied to particular situations.
Well, how about just fair notice? Never mind mathematical certainty.
It addresses a difficult problem that the court has grappled with over the years, and that is the scope of Congress's authority under Section 5 of the 15th Amendment, of the 14th Amendment to pass legislation enforcing the provisions of the 14th Amendment. And the one argument that has been made, which would represent a very narrow interpretation of congressional power, and this is basically the argument that Justice Scalia, the position that Justice Scalia took in the dissent that you mentioned, is that Congress's authority doesn't extend any further than remedying actual violations of the 14th Amendment, that there is no, Congress doesn't have additional authority to enact prophylactic measures outside of the area of race, which Justice Scalia would treat differently and recognize broader authority because of the historical origin.
Judge Alito,
14th Amendment.
what's wrong with the test of Maryland versus Wirtz and Gonzalez versus Rice as you take a look at power under the Commerce Clause and to be applicable to our legislation under the Americans for Disability Act? That a test is where the court has gone into some length to say what you have gone into repeatedly, that judges have no expertise. It's up to the Congress to have hearings, up to the Congress to find facts, up to the Congress to find out what goes on in the real world. And in Wirtz in 1968 and reaffirmed recently in Gonzalez versus Rice after Morrison, after Lopez, quote, where we find the legislators have a rational basis for finding a chosen regulatory scheme necessary to the protection of commerce, could apply as well to disability, our investigation is at an end. What's wrong with that test? Would you subscribe to that test over the proportionate and congruence test?
There are a number of tests that have been used and proposed over the years in this area, and this is the subject, I think, of continuing litigation in the Supreme Court. There is the Maryland versus Wirtz approach, and then the City of Bernie approach, and you mentioned that the City of Bernie is a relatively recent decision, and it's been followed by a number of subsequent decisions.
Where did it come from? Where did the Bernie test on proportionate and congruence come from, if not thin air?
Well, I think it was an effort by the majority in that case to identify a standard that would not strictly limit congressional power to remedying established violations of the 14th Amendment without going, but while still, in their view, retaining the necessary remedial connection to Section 5 of the 14th Amendment. And it is an approach that they have used in a number of cases, and the cases have not come out. Sometimes the results in the cases have not been predictable. You mentioned the contrast between the two decisions under the Americans with Disabilities Act. I think Nevada versus Hibbs was a decision that some people, that surprised some people based on the court's prior precedents. So there's, I think, still some ferment in this area, and I'm sure it is a question that is going to be, that will come up in future cases.
Well, we're speaking not only to you, Judge Alito, but to the court. Court watches these proceedings, and I think they ought to know what the Congress thinks about making us school children or challenging our method of reasoning. We're considering legislation which would give Congress standing to go into the Supreme Court to uphold our cases. Right now, the Solicitor General does that, but he's in the executive branch. We don't want to derogate the Solicitor General in your presence, Judge Alito. But the thinking that we've had was to speak about your decisions, the court's decisions on the floor. The Senate, nobody pays attention to that. Maybe we would try to come in as amicus. Why do that? We have the power to grant standing. We can grant standing to ourselves and come into court and fight to uphold constitutionality. Let me move at this point to the recent legislation which takes away the jurisdiction of the federal bench to hear habeas corpus decisions. It's in the context of the detainees. Justice O'Connor and Hamdi laid out the law in flat terms. All agree that absent suspension, the writ of habeas corpus remains available to every individual detained within the United States, every individual, not just citizens. And then she spells out the way you suspend the writ, and you do it only by rebellion or invasion. Then this recent legislation says the District of Columbia Court of Appeals shall have the exclusive jurisdiction to determine the validity of any final decision by the Combatant Status Review Tribunal. If it means what it says, and judges like to look to the statute as opposed to going to congressional intent, if it means what it says, that there's exclusive jurisdiction, there's no jurisdiction in the Supreme Court. This may come before the court, but what factors would you consider to be relevant in making the analysis as to, again, maintaining equilibrium between the court and the Congress of our authority to take away federal court jurisdiction on this important item?
In the area of habeas corpus, there are a number of important principles that have to be considered in reviewing any legislation that is argued to, that someone contends has altered habeas jurisdiction. The first is that the court said in a case called INS versus St. Cyr that if there is an attempt to, that habeas jurisdiction can't be taken away unless it's clear in the statute that that's what was intended. Habeas jurisdiction is not to be repealed by implication. That's one important principle. And then in Felker versus Turpin, which involved the Anti-Terrorism and Effective Death Penalty Act of 1996, the Supreme Court considered arguments about whether provisions of that legislation which restructured federal habeas review violated the Constitution, and they found that there wasn't a violation because the essentials of the writ were preserved. And so if other legislation is challenged, it would have to be reviewed under standards like that.
Judge Alito, I want to move now to a subject on efforts to have television in the Supreme Court of the United States. Subject very near and dear to my heart. I've been pushing it for a long time, and I'm personally convinced that it's going to come someday. I'm not sure whether it'll come during my tenure in the Senate. More likely to come during the tenure of Chief Justice Roberts in the Supreme Court, or your tenure if confirmed. The Supreme Court said in the Richmond newspaper case versus Virginia that, quote, the rights of a public trial belong not just to the accused, but to the public and the press as well. Such openness has long been recognized as an indispensable attribute in the Anglo-Saxon trial. And there are many other lines of authority, but only a few moments left to set the stage here. But the Supreme Court has the final word. We can talk about the president's war power under Article 2 and the congressional authority under the Foreign Intelligence Surveillance Act, but the court makes the decision. We can talk about taking away habeas corpus jurisdiction, but the court decides whether we can do it or not. We can talk about the insult of declaring acts of Congress unconstitutional because of our method of reasoning, but the court can do that. And the court has made these decisions on all of the important subjects. Court decided who would be president of the United States in Bush versus Gore. Court decides who lives on a woman's right to choose, who dies on the right to die, on the death penalty, on every critical decision. The Congress has the authority to do many things on the administrative level, such as we set the starting date for the court, first Monday in October. We set what is a quorum of the court, 6 members. Congress sets the size of the court. Effort made by President Roosevelt to increase the number from 9 to 15. We put provisions in on speedy trial, time limits on habeas corpus matters. In recent times, some of those who have objected to televising the court have been on television quite a bit themselves. When Justice Scalia and Justice Breyer come on TV, it's a pretty good show. Not much surfing when that happens, like surfing when my turn comes to question. But this proceeding on confirmation of Supreme Court justices has attracted a lot of attention. As I said to you yesterday, I'm tired of picking up the front page everywhere and seeing your picture on that. Brett Hume was on Fox News talking about going to a Redskins game in 1991 when Justice Thomas was being confirmed, and how he had his earsets on to listen to the proceedings. I think Senator Leahy was questioning Professor Hill at that particular time. But how about it? Why shouldn't the Supreme Court be open to the public with television?
Well, I had the opportunity to deal with this issue actually in relation to my own court. A number of years ago, all the courts of appeals were given the authority to allow their oral arguments to be televised if they wanted, and we had a debate within our court about whether we should allow television cameras in our courtroom, and I argued that we should do it. I thought that it would. It would be a useful
Really?
educational.
You've taken a position on this issue?
Well, I did, and this was one of the matters on which I ended up in dissent in my court. I think the majority was fearful that our Nielsen numbers would be in the
Could you
negative.
promise the same result? Could you promise the same result if confirmed to be a dissenter? Were the court allowed TV?
Be careful how you answer.
Be careful how you answer everything, as you have been.
The issue is a little bit different in the Supreme Court, and it would be presumptuous for me to talk about it right now, particularly since I think at least one of the justices has said that a television camera would make its way into the Supreme Court courtroom over his dead body, so I wouldn't want to comment on it.
Justice Souter, but quite a few of his colleagues have been on television. Well, let me ask you this, Judge Alito. I know what the answer will be with 7 seconds left. Will you keep an open mind?
I will keep an open mind despite the position I took on the Third Circuit.
Thank you, Judge Alito. We'll now take a 15-minute break and we'll reconvene at 11:35.
Take care.